We're going to start off this conversation with Stephanie, and she and I had a moment to catch up earlier. And it may start off grim, but we're going to get into it. Stephanie, the Children and Family Justice Center has been engaged in studying public defense in Illinois for 3 years now. Can you share some of the high-level findings?
I just wanted to say, before we talk about the stats, I know it's been said a couple of times, but I am so honored to be sitting in front of and beside the most important lawyers in the state of Illinois. I mean, without you, there is no Constitution to speak of. There is no Illinois state constitution. There is no United States Constitution. Think of the amendments. You all are protecting it in courtrooms every day, and I really appreciate that work. We represent young people in conflict with the law, and they need representation, and we know that they need time. One of the things that we have found, and you can see in your packets, Illinois public defenders are carrying workloads that are about 4 times the national recommended workload. And as you can imagine, trying to do work in that condition means that you are having to make trade-offs every day. People are doing their best. They're working really hard. You all know that. But when you're a client who needs to be represented, and you need not just to talk to your attorney, you need the full benefit of what a modern defense should look like, right? You need people who can assess the evidence, you go out, interview witnesses, review body cam footage, really engage in the work. So the extent to which defenders are underfunded and inadequately equipped is here in the data. I won't walk you through all of it. But what I want to say to you, getting this data that Julie was able to collect through 102 FOIAs of 102 counties was a snapshot in time. It's inexcusable, right? That this is the only way that anybody can get information about how many public defenders are budgeted. That's not how many public defenders are working in the state of Illinois, but at one point were budgeted, right? Unfilled positions, as many of you know, due to low work salaries, are rampant, a lot of turnover. There's about 1,000 public defense attorneys, full-time equivalency around the state, and there's about 300,000 cases that are coming through the system that a public defender ought to be assigned to. So the caseloads are very high, the workload is high, and I just really want to say thank you again for the work that you're doing.
This next question will be for you. Given what Stephanie just described, 4 times the workload, strained or non-existent budgets, how is that affecting public defense as a field? What does it look like for retention and recruitment, competition between offices that maybe are better resourced? How have you seen that impact the field through your work with the Illinois Public Defenders Association?
If you were paying attention this morning as the public defenders walked in and saw each other and realized who they were talking to and who they were, one of the first questions almost every one of them asked almost every other one is, how many openings do you have right now? It's the reality of our business that we may have FTEs in our offices, but we do have openings. I do hear sometimes that there are counties in Illinois that do not have an office of public defender. I just want to say, first of all, that is not true. Every county in Illinois has an office of the public defender. It may be in name, but there is an office in every single one of our counties. It may be shared between one attorney under contract, but that is the office. That doesn't mean there's a physical space, but it does mean that there is someone who fills that quote-unquote office. We're just like every other attorney in Illinois, and we're trying to recruit from a declining pool of available attorneys. From 2009 to 2023, the ARDC shows a 42% decline in new attorneys. From 2009 to 23, it shows a 61% increase in retirees. 23 is the first year that there was literally a net loss between those two numbers of 12 attorneys. We're getting older, and young people are less likely to go to law school and go all the way through and graduate. Cost of law school has increased about 20% nationwide over the last several years. Our attorneys are coming out burdened with over $12,000 on average of law school debt and over $135,000 of educational debt. They need to service that debt, and unless a public defender's office is capable of providing a starting salary that allows them to both have a place to live, a vehicle to drive, and service that debt, we're in trouble. We're not generally in strong competition with one another. The collar counties somewhat compete with one another. A county near mine got a raise in starting salary, and we managed to get one for our attorneys. Brought us back up. But we're all in competition with Cook County and people who perceive themselves as going to be on the murder task force in 3 years. Whether it's true or not, that's going to be up to them. But we can promise that we can give you experience trying cases right off the bat. Downstate, it's a whole different ballgame. And the attorneys that are going down there, Senator Sims talked about the desert, and it is real. And getting attorneys to go downstate and practice, it's primarily people who grew up in that region, in that area, and are willing to go into those practice areas. Without full staffing, it is difficult for us to fully staff our offices, and I'm sure we'll talk a little bit more about workloads and the unrealistic idea behind the new workload studies, because a public defender's office is almost never going to be able to meet that, and a small part-time public defender working out of his private office is almost assuredly not going to be able to meet that. One of the key things to remember, we don't choose our cases. We don't decide what cases are going to come through our door. They're given to us. And so that's part of this entire problem of making sure that we have the resources necessary to handle our cases. Sometimes it feels like we might be overloaded. We're almost always underloaded. So it's going to require a change in how we go about recruiting before we can begin retaining. And unfortunately, the key thing is money. Most of our loans are federal, and so forgiveness may not be necessarily on the table, but assistance from the state of Illinois is something that we can certainly talk about to get young new attorneys to see the possibility of not private law firm work, but government work through public defenders' offices and state's attorneys' offices, working in county courtrooms, handling our cases.
I appreciate the response. And I want to keep it with you for just a second to ask about morale in the face of everything that you just described. What can and what are public defenders doing, the chiefs, the deputies who have the experience behind them, who are trying to make sure that their offices are operational? What are you seeing as attempts to keep morale up, particularly with new and younger assistants coming in, and then Stephanie and to the others who may be working with law school students and new assistants? What are you doing that you find successful, or what are you seeing other offices do to help boost morale and keep people in the fight?
Last week, the Illinois Public Defender Association and the Appellate Defender's Office put on a joint trial advocacy program, and we had, Laura, how many attorneys were there? Just shout it out. 70. There were some 70 new attorneys and young attorneys in attendance at that program, learning from senior attorneys in the Public Defender's Office and in private practice around the state of Illinois. Their morale is through the roof. I see there are two levels of morale with public defenders in Illinois and assistant public defenders. I'd say there's mission morale, which I think is extremely high. The people who do this job because they want to do this job. It's what they want to be. It's who they have always wanted to be. But then there's systemic morale, and that is a little bit more difficult because it is frustrating to do what we do and to wonder, are we going to have enough money to do what we do? Am I going to have enough time to handle the cases that I've got to handle? In counties under 500,000 total residents, in only those counties does the public defender have to go to the judges to seek funding for the effort of indigent defense. Okay, great, but that's over 40 counties with under 500,000. That's practically half of our state are required to ask permission to spend money. And then they've got to go to the county board to actually get those funds if the judges say that we can have it. Though that level of morale is hard, and the frustration that a line assistant public defender experiences with large caseloads and moving cases through the system as rapidly as they possibly can to meet carrying times, et cetera, that's difficult. But the morale of the attorneys doing the job, the desire to stay and continue doing this job, if this were easy, anybody could do it, and that's why it's up to us.
I don't know that I can add much to that. I will say something that Keith did mention about recruiting downstate. You'll see in here some of the most under-resourced by percentage, I think on page 3 here. The top 5 counties with highest attorney shortfall. Just as one outlier example, Pulaski County, by our calculations, looking at how many cases are filed there, and Pulaski County, for those of you who don't know, is extreme southern Illinois, sort of in between Cairo and Tams. There's about a half of a full-time attorney who is practicing down there, and there should maybe be 8. But Pulaski County has 4 licensed attorneys in the county. So how can you have a public defender office that is staffed up when there aren't attorneys in the county? And as Keith said, that means that, traditionally people who are from the area are the people who are recruited, but it has been sort of a closed system then. And I see among our students who are very interested in public defense, if there isn't a job that's open in Cook or the collar counties, they don't know about it. They may not have connections to it. It's hard to even imagine yourself moving to a place that you don't have a connection to, but you could consider it if you were assured that you would have training, supervision, the tools to do your job, a decent enough salary to just pay your loans, make a life. And I think currently that information and those opportunities are just not there. And I'm hoping we can change that.
And I will just kick in one more thing, and that's, I think it was the ISBA did an attorney residence survey, and I think that's on the rural defense page of the ISBA's site. And if you want to despair, go and look. There are counties where there's 1 attorney resident in the county. Doesn't mean that's how many work. It could be 0. There's probably a state's attorney is the only person who is actually in that county on a daily basis. And then there are other counties like mine, Lake, where there's well over 1,000 attorneys resident, but only some 700 or 800 who actually practice anything close to full-time within the county. But that is really instructive as to where the bulk of attorneys in Illinois are and where they're unfortunately not.
Well, that's it. We're going to start off ground. And it is, but we'll keep digging in and we'll keep our morale up through this. I'm going to kick it over to Todd. When you were chief public defender in Adams County, you actually had a period where you had to stop accepting cases because of the workloads. Can you tell us what happened as a result of that and give us some insight to what that was like?
Sure. So I suspect that my experience in Adams County was not really unlike the experience of so many of you in terms of the workload that we had, the number of cases that we had, the number of attorneys, but it was our experience. So Adams County is a county with a population of about 60,000. And in 2022, our office was fully staffed. It wasn't adequately staffed, but it was fully staffed in the sense that all of the positions that we had were filled. And that was 8 attorneys and 2 support staff, secretaries. Beginning in 2022, there was a series of unfortunate events. One of our attorneys went on maternity leave. Later that year in the fall, there was mold that was discovered in the courthouse and significant amounts of mold, and particularly concentrated in areas where the public defender's office was. In addition to that, we had perennially low salaries, and all of you are familiar with that. But we had been lobbying year after year for additional positions and higher salaries. to no avail. So beginning in 2022, we began to have an exodus of personnel. Within about 9 months, we had 2 attorneys resign. We had one of our support staff go on extended medical leave, and there was a pervasive sense that the county was not really taking seriously the health effects of its employees, and in particular the public defender's office, with respect to the mold issue. County employees had received a letter from the county board telling them that they were not permitted to work from any other location except for from in the courthouse full-time. So public defenders especially felt underappreciated. They felt that their health was at risk. And so it was a combination of that and the low salaries that really kind of started this exodus. I ended up sitting down and having a meeting with our presiding judge. I told him that I believed that our staffing situation was going to be an imminent crisis because not only had we had the departures that we had, but there was additional staff that was anticipating leaving at that time. It was a good meeting, but there were no real tangible outcomes from that meeting. Shortly after that, in September of 2023, we had another attorney resign. And shortly before that, the stay on the Pretrial Fairness Act had been lifted. So we were dealing with a number of different issues on a number of different fronts in terms of staffing. I then sent a letter to the county board and copied our presiding judge and chief judge and told them that I believed that the situation was imminent and that we needed help immediately. And there was no response to that letter. So shortly after that, I determined that I think that we were in a position where we really had to do something. And the form of that was to respectfully stop accepting cases. I sent a letter to the judges. I outlined the number of felony cases that our office was carrying at that time. I also outlined a number of justifications for that decision. And in particular, I noted, first of all, my oath. I believe that my oath as a chief public defender to uphold the Constitution and discharge the duties of the office required that I take that action. I also believe that the rules of professional conduct required that I take that action, particularly the obligation to provide competent representation. I also believed that the rules that require managers to see that their subordinates comply with the rules of professional conduct also required that I take that action. I cited an ABA formal opinion, and then I cited some of the materials that you have in your folder, in particular Principle 3 of the ABA's 10 Principles of Public Defense Delivery System, which says, if workloads become excessive, public defense providers are obligated to take steps necessary to address excessive workload, and that can include refusing cases. So that was the position that we were in. Ultimately, that decision was met with mixed reaction on the part of the judiciary. Some judges, well, all of them essentially were taken aback. Despite the letter that I had sent them, they all seemed surprised that action was being taken. But ultimately, it came down to the individual judges. Some judges had very different reactions from other judges. Some judges were very much cooperative with the stance that I was taking. Other judges, while initially receptive, eventually ended up pushing back on that decision. And there was sort of for lack of a better term, some give and take as that process worked itself out. But eventually we were able to obtain some additional funding. We significantly increased some salaries in our office. And I was not fired. I was not asked to resign, but I did end up leaving the office shortly after that.
That is one of the unfortunate, I think, examples that is not isolated, right? Definitely a severe demonstration of what is happening across the state. But we know that these types of stories aren't isolated and very symptomatic of the infrastructure of public defense. And I want to turn to Dr. Copeland to really help us think about what the infrastructure of public defense and the lack of support and resources for the field are doing to impact the community. How are we seeing this play out in the community, both from your experience in your current role as a leading reverend, but also as a former public defender? How have you seen the impact of the community?
Okay, so I graduated from law school back in none of your business. And at that time, my mentor was Julius Lucius Eccles. If you've never heard that name, look it up. He was a criminal defense attorney here in the city of Chicago, and he inculcated in me the belief that public defenders are the defenders of the Constitution, with the champions of justice. We're the heroes of democracy. So I went to Kankakee County, and by God's grace, I was able to become an assistant public defender. At that time, cell phones, if you could afford one, looked like this. Now they look like this, and nothing has changed in the infrastructure and in the operation of how public defenders operate. I was not married. I'm a grandfather now. And nothing has changed. We were overworked, under-resourced back then in Kankakee County. When I started, we had one investigator, one support staff for like about 6 assistant attorneys who had to have their own private practice in order to be an assistant public defender. And I saw firsthand, not just because I was a public defender, but because my father was a pastor in that community, I saw how it was impacting the lives of people who just had the unfortunate circumstance of not having any money. Now, as a pastor, I've been pastoring in Rockford, Illinois for the past 23 years, and literally today, I drove up here because as I was driving up here, I called just to make sure I had the facts right. There's a person in Winnebago County Jail right now who's been in there 5 years, gone through 5 different public defenders, not because of anything other than the turnover. He's had to ask for, he's gone pro se so he could actually get discovery that he's never seen, and he is found in discovery and now is trying to get another public defender. He's found in discovery some things that he feels will help his case, but for me it was like deja vu. I remember this when I was like a young buck. Now I'm a graybeard, and we're still here. We're still at the point of under-resourcing and of not recognizing the impact, to your question, the impact it's having on our community as it relates to families who are being decimated simply because one individual has been charged with a crime, and even though there might be evidence of their innocence, they just don't have the money to hire the type of attorney that can stick with the case. And so now it becomes a cycle That is to say, you get a record, and even if you get out of jail, anything else that happens, it becomes sort of a snowball effect, and it starts having a deleterious impact on the community's impression of what justice is, and if justice is even possible in the system. I'll leave it right there because I feel like I'm talking too long.
Yes, let's clap it up for that. I want you to actually talk more because I think in this conversation so far, it's very clear, right, that we don't necessarily know or have the ability to rely on all the stakeholders really understanding how critical of a status public defense is in. You mentioned that judges seem surprised, right? Even though they should see in their courtrooms and you sent them a letter, right? I'm wondering, Dr. Copeland, from your perspective and talking about community, do you think community understands how critical the infrastructure of public defense is right now? Do you think they really have some insight into what staffing looks like, what funding looks like, and what would be good efforts to make the community more informed so they could be better advocates?
That's a great question. And I believe that right now, if you ask somebody just on the street, the idea would be if you have to get a public defender, you're going to jail. And most people, in addendum to that, and most people understand, not because of the quality of representation, but because you're not even going to see the lawyer. They don't have time for you. I believe, and I say that because I listen carefully to people who are on the street, and more importantly, we have a legal clinic in the church for civil stuff, and a lot of people come through thinking that they can get criminal defense. And as we start talking to them, the overarching sort of concept is that public defense, in the community, most people understand that public defenders are overworked, and therefore they're not going to get to your case, and therefore you're going to jail. I don't think, or it's been my impression, at least in Kankakee County and Winnebago County, that most people believe that public defenders are a lesser quality. It's more about they're not going to even see you, so there's nothing they can do for your case. They're not going to see you until you show up in court, and they probably aren't going to be able to explain to you anything about your discovery or any kind of plan for how they're going to address your case. And so part of what we've tried to do, to your question of how can the public become more aware of this infrastructure situation, part of what we try to do is just talk about justice all the time as a church. And again, we have a legal clinic that helps people to understand that, hey, this is, from our perspective as a faith community, this is a faith issue. This is not a political issue. This is a life issue. And everybody needs to understand so that we can be adequately equipped to be advocates for things like this, the Fair Act.
I think that deserves another clap. I'm curious too, and I'm going to turn this, hopefully not at the chagrin of those who let me have the mic, to all of us, because oftentimes, maybe at a dinner party or over cocktails, right, professionals laugh and say, like, people don't understand my role, they have no clue. But raise your hand if you think in your intimate circle of family, friends, loved ones, support system, if people you know understand the dire strait that the field is in. Raise your hand if you think they do understand that. Right. So we've got some work to do to make sure that lots of folks know what's happening to defense across the state. Stephanie, I want you to kind of remind us from your work of kind of following the status of public defense. How many public defenders are there in Illinois? How many cases is someone assigned to or as a part of their workload? And then maybe talk a little bit about what is needed for like national data to really make sure that we understand what's happening?
Sure. So again, there is about 1,000 budgeted attorneys, or at least there were, at FY23. We don't know. There is no state apparatus. And just for those who aren't aware in the room, it is the responsibility of the state of Illinois to ensure that every person who is arrested for an offense has the ability to have a lawyer if they're not able to afford one. It is not the responsibility of the county, although the state can delegate some things. It is the responsibility of the state. The way that our current system is set up was instituted in 1949. So before Gideon versus Wainwright, before there was a constitutionally recognized right to have a public defender. The good news is the state of Illinois was working on a plan. The bad news is it never did anything else of note. And as Pastor Copeland was saying, you know, it's been a long time, and the same things are happening. When we have been presenting our data to community groups, to interested people around the state, the one question that we keep getting over and over is, how could it be this bad and I never hear about it on the news? How am I not seeing more of this? And the answer, the only answer that I can provide people is, it's a structural problem. The reason that public defenders don't feel empowered to come forward about having untenable caseloads, refusing cases, is that our structure is highly flawed. The American Bar Association has 10 recommendations. We put it in your folder, and here's a chart on the back of this one handout that we have that shows how many of the 10 recommendations Illinois has completed. And you can look at the colors and you can come to your own conclusion. And I'll note that that first column is 1976. Since 1976, the American Bar Association has said, here's what you need to do to have an effective, well, it was not called that at that point, but it was a national committee that was looking at best practices. And the ABA has reiterated these same 10 principles over and over. Illinois is not meeting them. And one of the first recommendation the ABA has is that public defenders need to be insulated from both political and judicial influence. And it is those two things that keep, fortunately, I think in the last couple of years, the Public Defender Association has really come into its own and really been talking amongst each other about the state of things and having strength in numbers together. But prior to that, people who spoke out have had some repercussions, or at least rumors of repercussions. And the thing about a conflict of interest is it just has to be one perceived person in the state of Illinois that might have lost their job because they spoke out about unfair conditions for their clients for everybody to have their speech chilled, right? And it doesn't matter if somebody means to do that. It doesn't matter if it actually happened. The nature of a conflict of interest is that there's a sense of impropriety, there's a sense that it could happen, and we have a system that allows that to happen. So, I'll leave it there.
I feel like you held yourself back, and I was going to let you keep going because it sounds like a great time in the state to become more fair. But you were going to jump in.
Yeah, if I can. I believe she's hitting, to your question, I believe she's hitting on something that we sometimes underestimate, but we ought to have learned the lesson from the Safety and the Pretrial Act, and that is this. Some structures stayed the way they are because there are narratives around them that have not been audited or challenged. And one of the narratives, and we saw this with the Safety Act, one of the narratives is that, or let me frame it this way. We have to frame it in these terms. What kind of democracy do we want? The reason I say that is because many people, and we saw this in these last few years here in the state of Illinois, they think they understand what the Constitution says, but they don't really feel it in this way, that you have a presumption of innocence until you're proven guilty. Now, what does that imply? Well, that ought to mean that you shouldn't be in jail if you haven't been adjudicated as being guilty unless you're a danger to society. That sounds reasonable. But we all know the narratives that were going around, even with fake newspapers and a whole bunch of things online, against that very principle that is the bedrock of democracy. And so as long as we let somebody else control the mic, when I say we, I'm talking about the champions of justice, the people who are here in the room, public defenders, as long as we let somebody else control the mic, those structures are going to stay in place because they're staying in place through ignorance.
Is I don't let people call it democracy unless it is, right? So I think we can push against that too. And if you are going to continue to allow a system that is under-resourced, that can't build its infrastructure, that can't effectuate the constitutional rights of folks, and you aren't believing and actually demonstrating democracy. And we can start to hold people accountable for that. I'm gonna go back to you, Todd, because there have been some changes, right? We've talked about PFA, we've talked about Safety Act, but there's also been some changes that have impacted and in many ways kind of increased the burden of workloads, like use of body-worn cameras, right? And the labor that it takes to look at all of that footage. We're already talking about under-resourced offices, shortages in staffing. Can you talk about some of the changes that you've seen impact the practice of public defense? And what do you think those challenges will look like in the next couple of years to come?
So, yes, there has been a proliferation of all kinds of electronic evidence. Yes, notably, the mandatory body-worn cameras has contributed significantly to the burden of public defenders' offices. As was mentioned, the amount of time that it takes to review that video, but it also requires other things. It requires updating computer systems. It requires updating software, hardware, storage systems, staffing, as we've been talking about. So just that one issue alone significantly impacts public defense in Illinois. But there's so much other electronic evidence as well. We're under surveillance essentially everywhere we go now. And so many of the cases involve surveillance video. They involve looking at social media, cell phone records. It's just exploded the amount of information that public defenders are required to digest and analyze in addressing their cases. So that has been a big issue. Going forward, I know artificial intelligence is certainly also expanding rapidly. I know that there are some systems in place to help with looking at video. I don't know what all those systems are, but I suspect that going forward, and I hope that public defenders are able to make use of AI, at least when it comes to that issue.
You know, this all requires additional resources to be able to handle everything that you just described. But, you know, you raised a perfect example of then having to go to the judges and ask for those resources. What is that like as far as conflict and trying to do your job in front of the people who also hold the purse strings? Can you talk a little bit about that?
And that, that issue goes directly to the structural deficiencies in Illinois' public defense system. Public defenders are very much at a disadvantage when it comes to comparing their stance before judges with the stance that prosecutors have. Obviously, public defenders fall underneath the judiciary, and so the employment of the chief public defender is essentially controlled by the judiciary compared to the state's attorney, who is an elected official. And so there's, just beginning with that issue, there is a very significant distinction in terms of the level of independence. There are other factors as well. For example, that issue is just exacerbated by the fact that the county board is essentially represented by the state's attorney. And so the state's attorney has a very close relationship with the county board that the public defender doesn't necessarily enjoy. So there's a huge opportunity for political interference, judicial interference, fiscal interference, and all of those issues are woven together and affect each other, but it is certainly descriptive of the structural deficiencies in Illinois' system.
Thank you for that. Keith, these are all issues that the Public Defenders Association is addressing, is trying to build up, right, support for. Can you tell us, along with the association itself, what are some of the other strengths of the public defense system right now?
The biggest strength is our people. I can look around my office and see some 30, 35 attorneys, and I will fight you if you want to tell me that any of them are not skilled, competent, devoted, dedicated attorneys. And I see a bunch of other chief and senior public defenders in this room who will do the same for their offices. We care, and we're doing what we need to do. What we can't forget is who we're doing it for. We're doing it for our clients. And I've in the last 2 years, I've been on the Illinois Criminal Justice Information Authority, and I've watched the money go into that institution and go out in support of justice initiatives. And it's some very useful and good things. I mean, I've seen money going out for stab-resistant vests, for police dogs, for state's attorneys, victims advocates. Are those good things? Yeah, they are. But what I've started to see is that there is not money going out to serve our clients. They talk about victims. They talk about more money to support victims and more money to support, the police. And our clients are usually also victims. The victims are usually justice involved. We can't forget that. We serve not just our clients, but we serve safety and justice, because if we give our clients hope, if we represent them adequately on their cases, if we're able to go see them at the jail, able to see that maybe instead of a prison sentence, they're going to receive a probationary sentence and maybe some treatment or whatever else that they think that they might need in the community, then we can provide the hope that the Constitution is supposed to protect. If we forget that what we're here for is not just the public defenders, but for the people that they serve, and that is going to make our communities safer if we defend our clients and see them reintegrate into communities rather than just warehouse in our prisons, we create a safer community just like that stab-proof vest, just like that victim's advocate. And things like this, the FAIR Act, the PFA, have raised the issue and have raised awareness, and it's reaching the point where we are being seen. The Sixth Amendment Center's report on Illinois helps us to be seen and helps us to see the need for what used to appear to be spending money for nothing. Well, it's spending money for public safety and for justice, and not just justice, but, like I said, public safety and making the communities noticeably safer because our clients are stopping getting arrested, in part because of what we've done. That's what I think is the strongest thing that we can do moving forward, is hope.
I was going to say, Reverend Copeland, let him borrow a robe because he's preaching over here. Dr. Copeland, I'm going to let you end it for us. And we heard just in those remarks, right, about being client-centered, understanding that economic empowerment, right, is also a part of that. You have been a part of many campaigns for racial and economic justice. What makes this work to support and improve public defense a priority in that work, not just for you as a public defender, as an attorney, but for your entire church community?
Well, basically what he just said in terms of, I understand what public safety is really about and how this is an essential element of that. And I would like to go back to what I said also, is because I want to live in a certain type of democracy. I don't want the words of the Constitution to just be some kind of fairy tale. I want to see it operationalized. And quite frankly, in light of the fact that most of the people who are impacted by these issues look like me or are poor or are marginalized, as part of my faith tradition and as part of the sort of ethos of the people that I run with, we want everybody to be treated with dignity and everybody to have this hope that our brother was just talking about. Matter of fact, I got a slot open for Sunday if you want to swing by. But to your point, I think that this has to be a priority, not just for me or my community, but for these yet to be United States, simply because these issues are sort of at the foundation of what democracy is about and what we claim that we want this country to be about. So this is really the fight. This is, in one sense, part of what the for lack of a better word, the civil rights movement of this age is. And that is recognizing that the poor, the marginalized, people of color are being impacted a certain way through structural sort of strictures that can be addressed and that need to be addressed so that everybody can flourish and so that we can have a safe society.
I want to thank all of the panelists. This is an incredible group of folks. I believe in the work that you are doing. I am encouraged by the work that you're doing and the words that you have today. I wish that more people could have heard this, but we're going to open it up now to allow some questions from you all.
What do you believe was the persuasive moment to get the county board to get the money, to make the improvements? I'll call it a win, to get your win. What do you think moved the needle for you? Was that from you or however it got there?
Whenever we started declining cases, the judiciary had to call on the local private bar and appoint them. And in Adams County at that time, and still, it was a very limited number of attorneys. And quite frankly, the judiciary was having a very difficult time finding people. Also, the judiciary and the county board realized that this was going to get pretty expensive pretty quickly. And so I think there were some conversations between the judges and the county board, and they came to a unified decision that increasing salaries was the best thing that they could do at that point.
It's cheaper.
Yeah. Yeah.
All right. If we could give them another round of applause. Thank you so much.